All right, so what happens when there's a property and the property owner never left the will, never left the trust, there's no beneficiaries, and they pass away, they're deceased? Well, the property by nature will then fall into the probate courts, and the probate court will then elect an authority figure, in this case, an executor, with either limited authority or full authority over the estate's proceeds in the sale of the property and the personal property of the deceased. In almost all cases, in most cases, the authority figure is either an heir of the deceased or to someone very close to the deceased. If there is a will, there is a clear executor over the property's proceeds, unless this elected authority figure or executor in this case is not able or willing due to physical or mental incapabilities. Now, of course, notice of probate will be served to all the heirs of the deceased, either the direct mail or public publication methods if they're nowhere to be found. And proof of that is the petition for probate letter. Now, if there's no will, well, how do the courts appoint an executor? Well, they vote on it. The heirs will essentially vote on it. And if they can't come to an agreement, the court will then appoint an executor, one that's best suited, willing, and able. It's very important as a buyer's agent, if you're going to take on probate listings, to get a hold of the letters of administration. That's going to outline the clear executor of the estate of the deceased, and if they're going to have full authority or limited authority. It's very important to know the difference between the two. When there's limited authority granted to an estate of a deceased, that means that the court has to approve of any and all actions that the executor does with limited authority. This is a huge problem because this could delay the closing process. This could delay any and all decisions made on the property, the proceeds, the sale, everything. So make sure that if you're going to take a listing like that, make sure that to know if they are in either full executor or limited authority executor. 2, you want to get a hold of the petition for probate letter just to make sure that all heirs have been served notice, either the direct mail or public publication methods. And 3, get a hold of the death certificate. You never know if the deceased owner that passed away has liens, judgments attached to his name that weren't necessarily attached to the property, which could encumber and delay the escrow process, the closing process. This is very important. This could be a huge curveball to a lot of people. So make sure you get that death certificate, because just with the death certificate, with like the social, the name, and the information, typically title people are able to run that information and are able to clear the name if there's any encumbrances or any judgments that could, affect the closing process of the probate listing. Remember, just because you have a will on your property does not exclude your property hitting the probate courts come the case that you pass away, knock on wood. You need to have a trust with beneficiaries. A will just assigns an executor come to case that you pass away. It's still going to go to the probate courts. There's just going to be a clear executor who's going to be in charge. Put a trust, put beneficiaries, and you're good. Get in contact with a good trust attorney. Do you need to record your deed in order for your deed to be valid? And the short answer is no, you do not. However, recording your deed is highly, highly recommended.